So we just got some huge news. The Supreme Court just granted review to the first Second Amendment case that they will hear in a post-New York State Rifle and Pistol Association versus Bruen world. They have just granted review of a new 2A case. So let's talk about this. But real quick before we jump into this video, if you think it's time for the Supreme Court to strike down more gun control laws, go ahead and hit that like button and subscribe. As I mentioned in the intro, in this video, we're going to be talking about some really important news and some really good news. And that's the fact that the Supreme Court has just granted review to a new Second Amendment case. So next term, they will be hearing a new Second Amendment case in a post-Bruen world, and they will be applying their Bruen decision in a new case. That means that the Supreme Court will hear and rule on a new Second Amendment case coming up soon. The case is called U.S. v. Rahimi. It's a case that we've covered here on the channel that some of you may be familiar with, and this is going to be the next Second Amendment case that the Supreme Court is going to review. In this case, the government was actually the one seeking Supreme Court review because of a recent Fifth Circuit ruling, and it was a ruling on the federal prohibition on gun possession for people who are subject to domestic violence restraining orders. And the question was whether or not that's constitutional or not to essentially prohibit someone from possessing a firearm because they are under a domestic violence restraining order or other types of restraining orders without any conviction at all. In that critical Fifth Circuit decision, the Fifth Circuit three-judge panel analyzed the federal law, which was 18 U.S.C. section 922G8, under the Supreme Court's recent ruling in New York State Rifle and Pistol Association versus Bruen. So they used the Supreme Court's recent Bruen decision and they used it against that section in that federal law. Bruen requires that a government's restriction on the right to keep and bear arms must have a historical basis or analog that dates back to 1791. If it does not, then the law must be struck down as unconstitutional. The Supreme Court has now granted review to this case, and they will decide if they want to strike down that federal law prohibiting possession of firearms for anyone with a domestic violence restraining order, and they will apply Bruen against that section of the federal law. This decision has huge implications for other cases because we will get further clarification now in the post-Bruen world about how the Bruen analysis should be further applied, and we will get it directly from the Supreme Court. This will help to prevent a situation where other lower courts will maybe misapply Bruen in that Bruen analysis like they did after the Supreme Court issued the Heller decision. Many of you are familiar that after the Heller decision, there was a long period of time that went on where the Supreme Court did not hear any 2A cases, and that led to lower courts misapplying Heller, and then Bruen had to go in and correct the analysis. But now with the Rahimi decision, we will get further language from the Supreme Court to help prevent that type of situation. Now, the facts around this case are not great, and I want to state from the beginning that Mr. Rahimi and his criminal record is not good. He's not a good person. This is not the best factual case out of all the cases that I would have preferred for the Supreme Court to review, but we will take what we can get. There are plenty of other things during this whole case that Mr. Rahimi should have been convicted of and put away for, but the government here latched onto one section of federal law, which is that 922G8 section, and that's what's in question in this case. Some people say that this is a bad case for Supreme Court review because of how bad the facts are, but I think the Supreme Court will be able to look beyond Mr. Rahimi's criminal record and apply the Bruen framework faithfully against this section of federal law. So between December of 2020 and January of 2021, Mr. Rahimi was involved in 5 shootings in and around the Arlington, Texas area. On December 1st, after selling narcotics to an individual, he fired multiple shots into an individual's home. The following day, Mr. Rahimi was involved in a car accident where he exited the vehicle and then also shot at the driver and then fled the scene. He later returned to the scene with a different vehicle and then also once again shot at the driver's car. And then in January, he fired multiple shots in the air when his friend's credit card was declined in a Whataburger restaurant. The officers found out that was Mr. Rahimi. They showed up to his home, they obtained a warrant, they searched his home, and then they found a firearm in his possession. Mr. Rahimi had been alleged to have assaulted his ex-girlfriend, and then he had a restraining order put against him, essentially harassing, stalking, and threatening his ex-girlfriend and their child. The order also expressly prohibited Mr. Rahimi from possessing a firearm. A federal grand jury indicted Mr. Rahimi of possessing a firearm while under a domestic violence restraining order in violation of 18 U.S.C. section 922G8. Early in his case, he brought a challenge against that federal law, and he challenged it as unconstitutional. However, he lost that argument since prior in the Fifth Circuit had precedent which found that under the interest balancing approach, these types of federal laws were constitutional. He then appealed that decision up to the Fifth Circuit, who again found that that type of argument was foreclosed because of their precedent. But then the Supreme Court issued their decision in New York State Rifle and Pistol Association versus Bruen, and they reaffirmed that the proper type of analysis is not interest balancing, it's not the two-step approach, but instead it's text as informed by relevant history and tradition. In response to that recent Supreme Court decision, the Fifth Circuit panel that was reviewing Mr. Rahimi's case then withdrew their prior opinion and then ruled that under the Bruen decision, their prior precedent was no longer valid and that the federal law in question, which prohibited the possession of firearms and ammunition by someone subject to a domestic violence restraining order, is in fact a violation of the Second Amendment. That was huge. That was something that we saw really for the first time. Obviously, this decision did not sit well with the anti-gun side. It did not sit well with the government. And in fact, what ended up happening is the government there, the Attorney General Garland, then filed a petition for a writ of certiorari up to Supreme Court seeking Supreme Court review on their own. The question presented to the Supreme Court for review was whether 18 U.S.C. Section 922G8, which prohibits the possession of firearms by persons subject to domestic violence restraining orders, violates the Second Amendment on its face. The government goes on to argue that Section 922G8 fits squarely within the long-standing tradition of disarming dangerous individuals. They conclude their arguments by saying that this court should grant review so that it can correct the Fifth Circuit's misinterpretation of Bruen. So the government here in their petition was arguing to the Supreme Court that the Fifth Circuit misapplied the historical analysis in Bruen, and therefore the Supreme Court must take this case up and correct that issue. And again, that's really important because one of the things the Supreme Court will do when they review this case is they will see if the Fifth Circuit properly applied the Bruen framework. This is significant not just for 922G8 and that law in question, but this decision will also have broader implications, like I said. This decision of the court will have to apply the Bruen analysis against 922G8. That means we will get further language on when gun control laws like this one meet the text and history standard as set out in Bruen. This granting of review also clearly signals that the Supreme Court is in fact interested in more Second Amendment cases. That was one of the big questions coming out of the Bruen decision, was whether or not they would go a long period of time after and maybe not grant more 2A cases like they did after Heller. But here it appears by this granting of this review of this 2A case, and not really a hot topic 2A case, but it appears that the Supreme Court is in fact interested in more Second Amendment challenges. This also likely means there will be significant Supreme Court interest in other challenges and larger challenges like challenges to 922G1, which is the felon in possession of firearms and ammunition. Right now we have a case that's currently pending before an en banc panel in the Third Circuit, and they're addressing that very issue. That's the Range v. Garland case. The facts in that case are much better. Mr. Range in that case was a prohibited person simply because he lied on a food stamps application paper, and he became a prohibited person for the rest of his life. So again, the facts are better in that case. We're anticipating potentially a win out of that Third Circuit en banc panel. And then the question is, what is the government going to do? I think this also bodes well for other challenges that are currently pending before the Supreme Court, like all the ATF bump stock cases, the Cargill case, the Guides case, the Hardin case. All of those, I think, have a better chance now of being granted Supreme Court review. There are, of course, some cases I would have preferred over the Rahimi case just because of the facts in this case are not so good. But at this point, like I said, we will take all the wins we can get, and I'm always in favor of the Supreme Court reviewing more 2A cases. But of course, as we get more information, as things develop, I will let you all know. But this is big news. This is great news coming out of the Supreme Court that they will review a new Second Amendment case. Make sure you guys share this to everybody so they're aware and so that they know what's going on with the Rahimi case and why this is so significant. But if you guys have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. As always, I want to thank everybody who likes, comments, subscribes, who hits notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.